What should I know before suing in small claims court? Coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Very grateful to have you. I'm Jordan Farkas. I'm a retired attorney. I practiced a lot in small claims court. That was a specialty of mine. I've written several books, including books on small claims court procedure, and it's great to be back with you. I've made a kind of New Year's resolution, if you will, to produce more videos for this in response to popular demand. I've been very grateful to see a lot of subscribers since I did my last video, and in the gap between doing my previous videos and restarting to do more videos. So I'm very grateful for that and for all the comments. If you have not yet subscribed, I'd be very grateful if you took a second to hit that subscribe button and hit the notification bell so you don't miss a future video, and the like button as well. And of course, if there's a topic that you would like me to discuss in particular, you can leave that in the comments section below. As the channel is relatively in its infancy, there's a better chance that I will see that comment and be able to perhaps do a video on the topic of your choice. A reminder that I cannot give specific legal advice, but I can talk about small claims court in generality. And the goal here is to help you win your small claims court. Now, before we get to winning in small claims court, it makes sense to know what you should know before you actually sue in small claims court. Okay, so that's the topic of this video, and we're going to jump right in. For those who have seen my previous videos, you'll know that I use a trusty old whiteboard, very old school, bit of a dinosaur, I guess you could say. And I also have not been able to find my smaller whiteboard, so I'm using this kind of gigantic one, which kind of knocks me off the screen. Some of you will be happy about that. Others will like to see my pretty face on the screen. So I'll try and have both in the view. And also my intention is to get a smaller whiteboard so that it's not as awkward. So forgive me for that. So let's jump right in. And today we're going to once again discuss the things you should know before you sue in small claims court. This isn't an exhaustive list. In fact, I was thinking of some other things as I wrote this out, but I wanted to keep it to 10. And if you have any that you'd like to add from your personal experience, again, you can leave that in the comment section below. I'm always interested to get feedback. So number one on my list that I jotted down here is that it may pay to consult an attorney. Now, I know as a retired lawyer that may sound self-serving, but also because of my experience as a retired lawyer, and particularly with all the small claims court cases that I was involved in, I know that a lot of times the law, even for small claims court, can be very intricate. A lot of times the law is no different for small claims court on a $10,000 dispute than it would be for $1 million dispute, for example. Okay, and therefore it makes sense if you're going to go to court that you should know what the law says about your case. First of all, it can help you win in small claims court to understand what the law says. It could also help prevent you from taking a case that shouldn't go to court at all from taking it to court. Now, I understand, of course, that it really will depend on a lot of factors. Maybe the most concerning or the most relevant factor will be the amount of your claim. So obviously, if you have a $100 claim, a lawyer is going to cost a lot more than that for a consultation. There are a lot of lawyers that offer free initial consultations, but of course, the advice you're going to get in such a consultation is pretty limited. So I understand that the amount of money in dispute will matter. I also understand that the small claims court is meant to be a people's court. And in fact, in a lot of small claims courts, for that reason, lawyers cannot actually act for clients in small claims court. So I understand all that. But if the amount is a high enough amount where it's a considerable amount of money, every amount is considerable. Don't get me wrong. If somebody owes you money, you're entitled to sue in small claims court. But how it applies to lawyers anyways is that it has to be reasonable for consulting an attorney based on how much is owing. Okay, like I said, if you're owed $100, you're not going to go spend $1,000 on an attorney or whatever attorneys charge for consultations. That will depend on the jurisdiction where you're at. But just definitely consider it. If you have an amount that's a lot of money before you go to court, it could very much pay. In fact, I do suggest it to consult with an attorney beforehand. That's number one. Number two on my list is that it can often be resolved before you sue. So it's kind of similar to consulting with an attorney, because one of the ways in which a small claims court dispute can be resolved is through a lawyer's letter. Sometimes it's called a 7-day letter, a demand letter, a collection letter. So very often these types of letters from lawyers will actually help to resolve a dispute. So that's another reason why it pays to consult with a lawyer. But not just necessarily with a lawyer. Depending on how toxic the relationship is between you and the person who owes you the money, if things are somewhat civil or there's some communication still going, sometimes you can actually resolve the matter before running straight to court. So if somebody missed a deadline to pay you, you don't want to run to court the next day and say, oh, he didn't pay me on time. Maybe there's a reason for it. Again, this may sound obvious to a lot of you, but you'd be surprised. A lot of people get very hot-headed and they think to themselves, well, I've got small claims court, I'm just going to run to court. And for a lot of the reasons I'm going to continue to discuss here, it's not like going to court is always the most ideal option for you, which sounds funny coming from somebody with a small claims court YouTube channel, but that's the reality as I'm going to get into. So always bear in mind that oftentimes a dispute can be resolved without ever setting foot in a courtroom, and that actually is ideal. Okay. In a future video, I intend on talking about the benefits of settling. Yeah, even though you're not getting 100 cents on the dollar, a lot of times it can pay to get less than that for a quick resolution and money in your bank. That's probably the topic for a future video, but just bear in mind it is more ideal if you can resolve the dispute before you even set foot into court. Number 3 on the list that I have jotted down here is there are time limits. And I've talked a lot about this in previous videos. And by the way, for those who have watched all my videos, you may be asking yourself, well, there's a lot of overlap here in this video and other videos. And I do understand that, but a lot of times just how things get presented and packaged in different ways can resonate more with different viewers. So a lot of times there will be overlap because a lot of the concepts are the same, but once again, it really depends on the jurisdiction of where you're at for understanding what is the most important before you go to court. And therefore, I'll talk about various topics that repeat themselves in different videos. Also, the reality is that I do recognize that somebody who sees this video may not see a previous video, etc., etc. And one last thing is that the more you hear something, the more it kind of seeps into your mind. So it doesn't hurt to hear concepts more than once anyways. But in any event, getting back to what I jotted down over here, that there are time limits, that's an extremely important one. So a lot of times people will say, I've seen in the comments, somebody's done this to me and it's been going on for 6 years. So right away as a lawyer, I immediately think, well, you may have a limitation period problem. It's called the time limit is often called a limitation period. Maybe you've heard the term statute of limitations, depending on what jurisdiction you're at. But the reality is in virtually all small claims courts, you can't just sit on something forever and expect that you can sue one day, okay? Because the courts want to know essentially that there's finality in a matter. Nobody should have to look over their shoulder. Even if there's somebody who owes money, nobody should have to look over their shoulder for their entire life, especially if it's somebody who does not owe the money. If somebody's concerned that he may be wrongfully sued, nobody should have that hanging over their heads. There's all sorts of other policy reasons behind why there are limitation periods to sue. Also because the evidence could get lost or destroyed. It's harder to understand over time. Things get blurry over time. So there's all sorts of reasons behind why there are limitation periods to sue, but you should be very much aware of that before you sue. Now, there are times, and again, this is going a bit down the rabbit hole, I could get into this in future videos, where you can sue even if there's a potential limitation period problem, and you can worry about arguing that in court. So if you think you're out of time, I'm not saying you should necessarily not sue, but just be aware of the fact that the defendant may make a limitation period argument. It's another reason to consult with an attorney, because an attorney will be more well-versed in what the limitation periods are for any given case. Number 4 on my list, moving right along, is that you must prove your claim. Now, this probably sounds obvious to a lot of you as well, and invariably it is pretty obvious. But again, a lot of people, they get so emotionally tied to their claim, they kind of just assume that they're going to go to court and the judge is going to understand, or whoever the decision maker is in the small claims court in your jurisdiction. Some places have deputy judges, like in Ontario, Canada, where I'm from originally. Some people have judges themselves, justice of the peace. Whatever the case is, the decision maker, some people just assume, oh, I'm going to go to court and everything's going to be clear and then I'm going to win. Now, the reality is, though, is that you've got to prove to an objective decision maker what your case is about, what transpired, and why you're owed the money. Okay, so you have to bear that in mind. And I've done other videos about how to prove your claim and how to build your case. So you can check out those videos about how to make sure you've got good evidence for your case. But just know that the decision maker is not just going to look at you and say, all right, here's your money. It doesn't work like that. You always have to be mindful that whatever transpired, you have to prove it. So that also means if something's murky and can be somewhat confusing, you have to be able to make heads or tails of it for the decision maker so that they can find it in your favor in the small claims court. Number 5 on my list on this awkward whiteboard is that you must have damages. And I talked about this in this last video that I just did. I'll put a card up over there where you can watch that video. So what do I mean by damages? You have to have suffered a loss of money. In some courts, there will be other types of losses where you can prove, okay, but let's keep it simple for the purpose of this video. You have to have a loss. Right. So the last video I did as an example where, I've had people say to me, well, I got scared because this guy did this thing. And I said to the person, okay, did you lose money? No. Did you go to a doctor because you were scared? No. Any trauma? No. So, okay, you were scared for a few minutes. Okay, I sympathize, but where's your claim? Okay, and that's just one example. So you actually have to have a loss in order to go to court and have a judge, or again, a decision maker make a finding in your favor to give you a judgment. Okay, and also tied with that, as I also talked about in the last video, is that in virtually all jurisdictions that I'm aware of in small claims court, you have to mitigate your damages, mitigate. You have to lessen your damages. Courts want to know that you're not just kind of sitting on your losses without doing anything to try and avoid having those losses. So for example, let's say you had a rental agreement with a tenant, and the tenant left early. And again, some jurisdictions there's special landlord-tenant boards, so that wouldn't really fall within small claims court. But just for our example purposes of mitigation, let's say a tenant left with a 1-year lease and there's still 6 months remaining. So generally, courts want to know that you did your best to find another tenant to replace the tenant who left so that you minimize your damages. Okay. And you yourself, by the way, because there's no guarantees in court, which I'm about to get to, you want to try and lessen your damages anyway. Obviously, you're not just out to get the defendant for all the money. Of course, if you cannot recover any sort of money, then go after the defendant by all means. But you want to try and lessen your damages, and the courts want to know that you tried to do that as well. Another common example, by the way, is an employee who's wrongfully dismissed. Courts want to know in general terms, for the jurisdictions that I'm aware of, that the employee is doing what they can to find another job, not just trying to go after the last employer, as a reprisal for getting rid of them. And it's understandable to be emotionally charged, but courts want to know that an employee is doing what they can to minimize their losses as a result of the wrongful dismissal. Okay, now next on our list, number 6, is that you must collect even if you win. Okay, so a lot of people don't realize that, again, I keep giving this disclaimer because I can't possibly know every single small claims court inside and out across the world, but generally, small claims courts do not get involved in terms of collecting. They have mechanisms. When I say they don't get involved, they have mechanisms and procedures, but it's not like the judge gives you a judgment and hands you a check right there. I'm talking about checks. Speaking of dinosaur, how many people use checks these days? Gives you money, whatever the case is. Even if you get the judgment after winning, you still have to go and collect on that judgment. And I've talked in earlier videos about various ways of collecting and enforcing on your judgment. It's called enforcement or collecting on your judgment. But just bear that in mind. Don't expect that when winning in small claims court is all there is to it. Oftentimes I'll call that half the battle. Winning is half the battle, I used to say to my clients a lot of times. Okay, not only do you have to win, you also have to collect. Again, that's not to discourage you from suing for what's rightfully yours, but just know that you actually have to go and collect even after you win in small claims court. Number 7 on the list is, as I've talked about already a lot, there are no guarantees. Okay, so I think I've gone through that a lot, that when it comes to small claims court, you can never be guaranteed that a judge or decision maker is going to see it your way. Okay, even myself, nobody wins 100% of the time. Okay, so there's been cases where I thought for sure that they were foolproof and there's no way, like, well, I didn't actually think that, but one would think, if I wasn't more experienced, I would have thought there's no way my client could lose. It's so obvious. And it ended up that the judge didn't see things that way. Conversely, there's been times where I thought the judge would never see it my client's way because a lot of the issues were very murky, and the judge did. So there's no guarantees in court, which goes both for the plaintiff and the defendant. And I know a lot of these videos, by the way, in fact, I think all of them have been from a plaintiff's perspective, somebody suing, and in the future, and that's the reality of most people that are looking up small claims court on YouTube. But if you're a defendant and you'd like to see some videos on, how to defend a small claims court lawsuit against you, leave that in the comment section below. That will encourage me to start looking at it from the defendant's point of view. Obviously, as a lawyer, when I did small claims, I defended many people. I acted for defendants and plaintiffs, okay? But from a plaintiff's point of view, just know that there's never any guarantees when it comes to small claims court. And as I talked about before, that's another reason why it's a good thing to try and settle in general, and also to resolve disputes even before you get to small claims court. Oftentimes, small claims court is a last resort. In fact, I would say virtually always small claims court is a last resort. Video number 8, you may need witnesses. So this probably should have come after the part about having to prove your claim. A lot of times, as a part of proving your claim, you need to have witnesses that will bolster your credibility. Sure, in small claims court, because it's a people's court, it can be that the judge will just take your word for it and your testimony is enough. But other times, let's say you say that the counter was, for example, you had a dispute with a contractor or a renovator, and you argue that the counter was damaged and the renovator says it wasn't, then you may need to get a witness in, possibly even an expert witness who says, no, this counter should not look like this and it has been damaged. So you can't always rely on the fact that you yourself could be the only person who's going to be in small claims court. You oftentimes need witnesses. And because of that, you have to understand that you're going to need these witnesses to not flake out and actually come to court with you if this matter goes to trial. So just know that oftentimes it's not just dependent on you. You are going to need that sort of those supporting actors, if you will, that outside support who will come as witnesses to prove your claim. In fact, it's advisable in most cases to have witnesses to help bolster your claim, unless those witnesses are hostile to you, obviously, or if they're not very reliable, or if they're likely to do more damage by saying something that they shouldn't. So it's not always the case, but oftentimes it is a good thing to have witnesses. And just know before you sue that you're likely going to have to need witnesses. If it was a contract just between you and one other person and nobody else is aware of it, okay, I understand. So you may not need witnesses there. But in a lot of cases, witnesses will be very important, and you have to know that before you sue. Number 9 on the list, getting to the bottom here, is that it can be stressful. Okay, so it can be very stressful to go to small claims court because of some of the things I talked about. There's no guarantees that you're going to win. I'll get to this in the last point of the video as well, point 10. But it can also be stressful because it takes time away from work, which I'm going to get to in a second. It can be stressful. This is something I didn't put on the list, but I easily could have. It can be stressful because you actually have to locate the defendant in order to sue them, and finding them, a lot of them run off and you don't know where they are. It can be stressful for because let's say the defendant that you sued says not only do they not owe you money, but you owe them money, then they can counterclaim against you, and that can be very stressful because not only are you trying to collect money that you feel is owed to you, they may be trying to collect money that they feel is owed to them from you. So you may not only win your case, you may lose and have to pay out money to the defendant, which is not a very pleasant thought. These are just some common examples, but there's all sorts of reasons why going to court can be stressful, dealing with the bureaucracy and the administration. Again, I'm not saying this to discourage you from suing what's rightfully yours, but just know a lot of times small claims courts can be stressful. And what ties in with that is point 10, is that it can cost you time away from work. So you do have to consider the opportunity costs when you're considering going to small claims court. Okay, I've heard a lot over the years, it's the principle of the matter. And I admire somebody who wants to stick to principles. I get that. But let's say your dispute is over $100 and it's going to cost you $300 in lost wages to go and sue. Is it still worth it to go for the principle of the matter? You may say yes, and that's a personal decision, but just be aware of that a lot of times going to court could entail multiple visits. I know nowadays, as we're approaching 2026, as I record this video, that it can be that things are done digitally and on Zoom or whatever the case may be, but that doesn't mean that that won't take time away from your life as well. It's not just work, it's time away from family. So once again, I keep repeating, it's not to say you shouldn't sue for what's rightfully yours, but just know that it can be very time consuming and take you away from other activities that you could be doing. So you should consider the opportunity cost associated with suing in small claims court. So just to summarize this list, I'll try and go through this very briefly. Number 1 is that it may pay to consult with an attorney because small claims courts, it can entail legal matters that attorneys can be better versed to help you with. I also talked about limitation period, where an attorney will understand limitation periods better than you will as a layperson. So it may pay to consult with an attorney. It will depend on how much money is owing, of course, and how much the attorney charges. Number 2 is that there are time limits, as I just alluded to. So, you can't just sit on something for an indefinite period of time and expect that you can walk into court anytime. Just know that the clock is ticking and be aware of that before you sue in small claims court. Number 3 is that you must prove your claim. Don't just assume that a decision maker in small claims court can read your mind. You're going to have to prove how much is owing to you, which ties into point number 4, is that point number 5 rather, which is that you must have damages. Okay, so you must have you had to have suffered a loss. Just to say that you got scared for a moment without any actual trauma or medical visits or anything like that is not enough. That's just an example that I use. You have to have actual losses, or a loss, I should say. Number 6 is that you must collect even if you win. So the decision maker, the judge of small claims court, doesn't hand you a check on the spot, even if you do win. You have to actually go and collect after you do win in small claims court. Number 7 is that there are no guarantees. There's no guarantees you'll win, no guarantees you'll collect, even if you do win. What would be an example of not collecting even if you do win? Let's say the defendant goes bankrupt, for example. Okay, maybe you can't find the defendant. You get a judgment, but then the defendant skips town. Okay, so there's no guarantees, and you should be aware of that before suing as well. Number 8 is that you may need witnesses to help prove your claim, so you can't always rely on the fact that it's going to be you alone. Sometimes it will be, depending on the circumstances, but oftentimes you'll need witnesses. You'll have to make sure that they can attend court and testify for you. Okay, number 9 is that it can be stressful, as I just finished talking about moments ago, for the reasons we talked about, because there's no guarantees, also because you're dealing with somebody that you had a bad interaction with. There's a lot of uncertainty and unpredictability, time away from work, which is number 10 is another reason why it's stressful. So it ties together. You may have to be away from work a lot or away from family. Small claims court can be time consuming, both for, preparing and filing the lawsuit, going to court and trial, the various procedures, and then collecting if you have to, if the defendant doesn't pay their judgment on time. Okay. I hope you found this list helpful and hopefully not too frightening, because the point is not to frighten you away from suing for what's rightfully yours, but things that you should be mindful of before you sue in small claims court. If there's something that you know from your experience that maybe I missed, because again, this isn't an exhaustive list, I'm sure there's many other considerations, feel free to leave that in the comment section below. If there's a topic you'd like me to discuss, you can leave that in the comment section below as well. And once again, those who subscribe, thank you so much for subscribing. I really appreciate it. If you haven't yet, if you could take one moment to hit the subscribe button and the notification bell so you don't miss a future video, that will encourage me to continue producing videos just like this one to help you win in small claims court. You can also like the video and share it with anybody who you know is maybe having a small claims court issue, can benefit from this video as well. Thank you once again for visiting, and until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.